I'm an attorney. I guess they saved the best for last. Now I'm going after all the medical speakers. I'm going to talk about effective and compliant contracts for medical practice. And I'm licensed in California. I am the president of Solve and Win. Our slogan is we solve problems and win cases. I'm more of a preventive legal attorney, so I do the transactional work, putting contracts in place to prevent liability. I'm of counsel to two different law firms. Alliant does asset protection, and Marino Yebri does litigation. I'm also general counsel of Beverly Hills Rejuvenation Center, which is a multi-state medical spa, and they do franchising. I'm also the founder and CEO of two startups, and I might mention LawTake because it is an online platform that has many contracts created by attorneys, and many of them are low cost, and then it also has videos. We're recording this right now, so if you have colleagues who couldn't attend, it should be on LawTake. And then also Think Do It is a patent pending medical device that I'm working on with some doctors, and my office is in Century City. Here's some publications that are relevant to this topic. If I don't go into it, you can check them out. They're on my law firm websites or on other websites that are listed. One of them has to do with another topic that we learned about the other day. When people post negative reviews, I wrote a specific list of how I suggest handling that situation so you don't have to send a cease and desist letter. Then many people ask me, should you sue, even though I don't litigate, and I have an article about that. Obtaining patient permission before using videos on your social media. I have an article about specific releases that you need that are not only obviously entertainment law related, but healthcare law, HIPAA compliance issues. And those are just some speaking engagements that I've done. So my disclaimer is that my presentation does not constitute legal advice. It's only for informational purposes. And disclosures are that I do represent Keon, so I don't want to hear about any legal issues related to this conference or any of the other speakers who are my clients, unless you want to waive the conflict. So the overview of my presentation is that I'm going to obviously talk about what is a contract, different types. Probably some of you are employees or independent contractors or the employer. I'll just talk about how that's related to contracts. I'll go over some example provisions that are in contracts and how to look at them. The confidentiality issue related to healthcare is important. Same thing with supervision issues. Compensation, that's related to the anti-kickback. How do employment laws come up? Sometimes we don't want it to be a contract, and I'll discuss that, and then I'll kind of backtrack to the negotiation tips that you might want to have when you're negotiating the contract, and then how to avoid a dispute. Okay, so what is a contract? A contract, it can be obviously in writing, but it may not be. It may be verbal agreements that can be proven by performance. It can be text messages, and it can be a confirmatory email. I've seen people go after people for breach of contract over, the claim is breach of contract, but it was the whole agreement was done via text messages. And that's submitted as evidence. My client won her case based on a contract with text messages. Sometimes you want to send a confirmatory email. I had a client call me because, I'm sure there's some pharmaceutical reps in here that may have made promises. And unfortunately, my client was the medical practice, couldn't get them to perform, but it wasn't in the contract, he never wrote a confirmatory email. It's harder to prove. So in general, a contract needs to have offer, acceptance, and consideration. And some people ask me, well, what about an NDA? What's the consideration? Sometimes that can be just the continued employment, and then sometimes that can be just something nominal, or the accepting the confidential information. So you want to have it signed, and sometimes you can still go after somebody for breach of contract even if they don't sign it. So just in a nutshell, what is an effective and compliant contract? To me, an effective contract is one that you've read and understood, and if you don't understand it, then you should try reading it out loud. The other party who you want to have comply with the contract should also read it, and you should go over it with them. And for it to be compliant, unfortunately you need an attorney to usually make sure that year after year it's in compliance. So, see, there was a typo there. But so different types of contracts. We have intra-practice agreements and then inter. So you have your inside practice contracts. Those are between the professional corporation perhaps, and then the staff and clinicians, or if you're an MSO, then you would have it with those employees and independent contractors. Just real quick over an offer letter and an employment agreement and an independent contractor. An offer letter is when you have at-will employment. You don't have them working for a specific term, and then the employment agreement is when you want them for a term, and then you want them to, if you want to terminate it, you need to have the reasons for cause. I've seen this become an issue because a client, I did the offer letter for them, they made changes, they put a term in there. You can't have your cake and eat it too, so when they tried to terminate somebody for any reason, the person tried to dispute that, saying that they should get paid for the entire term. So my client felt like it was a shakedown, he had to pay, and the moral of the story is he should have had me review that addition, and I had already explained it to him, but unfortunately these things happen with companies and with employees who don't perform. So then you have the Delegation of Services or standardized procedures and protocols with your staff, and I will go over that a little bit later. They need to be signed, so it's kind of like a contract, but it's not like you would go after them for breach of contract or anything. And then inter-practice agreements, your vendor contracts, your contracts with patients. We've talked a lot about informed consent and what should be in there, what should be disclosed. I think keeping them as thorough as possible. And obviously your HIPAA package and notice of privacy policies. The business associate agreement is related to HIPAA. It needs to be with all your vendors who may have access to protected health information. So then, people ask me, can we still have independent contractors? This new law came out last year, the Dynamex case, and California adopted this test from New Jersey. It's called the ABC test, and it's instead of 10 factors that we used to have, it tried to make it more simplified to 3. So I just always tell my clients, well, how much control are you going to have over them, or are they really independent? If you're hiring the web developers or your attorney, they're independent, they're free from control. If you're a medical practice and you're hiring people who provide medical services, it's really hard now to make them independent contractors because they're doing that exact type of work. It's not independent. So outside work is a factor, and then customarily engaged. If they're a part-time practitioner, I'm sure they're engaging in practices outside of your practice. They may have other jobs, but those are the 3 factors now that the courts look at, and it's not clear. And some of the bigger companies are making everybody employees because they don't want the risk, and some of the smaller startup companies that I represent are slower to follow. So then. There are some benefits of having an independent contractor. If you can, it's obviously less costly for the business. There's less rules, it's less litigation. For the practitioner, the reason why many workers don't want to be an employee is because they want the flexibility. They have better negotiating power as an independent contractor. So there's benefits for both parties if you can, and that sometimes needs to be discussed with specialized employment counsel. So example provisions, there's so many different provisions that are in a contract. These are just a few that I thought were important. You would be surprised, but sometimes people don't even fill in who the parties are. If you're ever audited, you're trying to prove that you had this contract and it was HIPAA compliant and the parties aren't filled out. And you want the parties' information. If there's a dispute, you give the contract to a lawyer. Nobody can find this company, so it's good to make sure you figure out where the company is registered or where the person is located. What are the obligations? So if I'm representing the person who's paying, I don't want hardly any obligations. I just want, it's going to say they're going to pay them. But if I was representing the other side, I might want make sure they provide information that's going to help with the services and other types of obligations of the person paying, like when and how often. So, and then if they maybe don't pay on time, adding interest. If you are the service provider, you want your services to be very broad because you don't want to be told that you didn't provide the services. If you were the one who wants the services, you would want it to be very detailed. You want to get what you're paying for. Then you may have a timeline for delivery. If you're having somebody do your website or do some remodeling of your office, then you want to know when these certain benchmarks are going to be reached, and maybe you want a time is of the essence clause in your contract. And then what are the deliverables supposed to look like? This can be just an exhibit. Okay, I like how this looks. This is what I want it to look like. So that way it's more specific. And all this stuff takes more time, but it makes the whole business relationship go much more smoother if you spec this out in the beginning. I know this because I have my own businesses, and then I'm general counsel for other companies as well. So then you have the, if you're the person who's getting paid, you want to know when you're getting paid. Maybe you want it all up front. Maybe, like I said, you may want interest if you're not paid on time. And then the term, how long is this going to take till it's completed? Or if this is a contract that's for 1 year, maybe you want termination with 30 days notice. What is considered breach or default can be put in there. It's not always in there, but sometimes if you're concerned that there may be a breach, you can say, hey, per 4C, you have breached. It just makes it much easier to handle things when they're not going as smoothly as expected. I'm going to go into more detail in confidentiality coming up. Insurance is important because you can have your errors and omissions, your general liability, workers' compensation, but who is supposed to be the one procuring the insurance? Have you reviewed your policies? They are negotiable. An indemnification provision, a lot of people don't know what this means, but it is important. If you're sued and it's not your fault, it's the other party's fault, then you would want to be indemnified. So that means they would have to pay for the defense costs because it wasn't your fault. So sometimes it's mutual indemnification. Sometimes one party wants to be indemnified, the one I'm representing, and if the other party doesn't ask for it to be put in, then that's their problem. The dispute resolution is also important. I'm going to show you some examples coming up of contracts, and just having them resolved in California court doesn't keep things confidential. It can take a long time, so I usually recommend arbitration provisions. You're all familiar with arbitration agreements. It can be a whole couple of page agreement, or it can be a small paragraph. And then assignment is usually a standard provision, but it's important because if you contract with this amazing contractor to remodel your office and then they assign it to somebody who's not as great, you're not going to be happy, and you should require written permission prior to any assignment. So everybody knows what a HIPAA is, and I don't want to get too detailed on the slide because I think we're going over time, but there's also high tech, and there's also California Civil Code. So they all talk about not just protected health information and protecting it, but also compliance issues, penalties, and the personal and financial information of people as well that is through the California Code. And to protect the PHI and other trade secrets, you want to have every worker, every employee to sign it in their employment agreements that they're protecting confidentiality. Also, any inventions that come up with during the employment or during the scope of work, maybe as the employer or the person who's paying for the services, you want to either have them assign it to you, or if it's the same thing with an independent contractor, you want to be able to obtain control over those inventions, the trade secrets, and keep it confidential. So you want to clearly define what it is, and then you want to have these NDAs in place upon hiring, upon any kind of promotion, changes in work. My mom's cousin actually worked for Allergan. She's on the patent for one of the Botox uses, and Allergan's making billions because she was an employee, and that's just the way it goes when you're an employee. So make sure to have those contracts in place. So supervision issues, this is related to actually, when you think about how medical practices can have problems with legal issues, a lot of it just has to do with patient complaints. It's not just employment issues. It's like both of those really impact the practice. And so there's this patient safety story that talks about Dr. Garrison's practice. You can Google it or you can email me for it. It's about a 100-page story. It involves a medical board complaint revoking his license, and basically he was just supervising too many places, and too many staff members, and they didn't have very good standardized treatment and protocol procedures in place, and so that you can be audited, you can have a complaint, and then they're gonna subpoena these documents, so you want to have them in place and possibly reviewed, because sometimes I've seen it very jumbled together, it's not clear, it's not signed, it's not looked over every year, or more frequently than that. So just make sure you have those. The other thing that comes up frequently is the Anti-Kickback statute, Stark, and this is just like the checklist that attorneys use. most of my clients are medical spas, or they're not accepting money from federally funded healthcare programs. So even though they're not, there's still, and everybody, a lot of times I get asked this, medical spas can't, even for aesthetic treatments, we can't pay referral fees. Sorry, there's California Business and Profession Code 650, and it talks about the exception. And so I'll just show that. So it prohibits the offer, delivery, receipt, or acceptance by any licensed person. So offer or acceptance of the licensed person, and of any rebate, refund, commission, preference, and to induce basically referrals. However, section 650B does have an exception if the consideration is commensurate with the value of the services furnished, or fair market value, or fair rental value. And that comes into play because many times my clients will ask me, well, what's fair? Should the management service organization get 50% for all the management services? And I'm like, well, are they renting space? How much is this space worth per square feet? What is your license fee going to be? What are your marketing and advertising services? There are ways to do percentages, or there's ways to do flat fees. It all needs to be structured and analyzed. It's very fact dependent. This I've sent to at least 3 different clients in the last year. They're like, can't we pay a hairdresser a referral fee? Can't we give somebody a gift? And I just send them this because as the attorney, I'm like, this is the law, and you're going to make the business decision. Healthcare is very it's a high risk area of law, and so these bullets are what I tell them. It just, like I said, has to be fair market value. It needs to be based on effort, not income and results. So there's this thing called KPI, key performance indicators, that you can build into your agreements with your staff that shows that they're getting paid based on productivity and not just based on the net result. And then obviously prospective agreed to in advance. So not, oh, you just referred a patient, let me give you money. No, it needs to be in advance. This is what you're going to get for doing this. And so that's what I tell people, and they make their own decisions. I don't want to go into each of these too much because they're not always related to contracts, but the employment law issues come up, and so just be aware of the meal and rest breaks and the payroll and harassment, whistleblower issues, and mandatory sick leave. People ask me, do I have to give my employees paid time off? And California and Los Angeles does have mandatory sick leaves. It all depends on the number of employees you have, how many hours they're working, and so how long are their shifts. So it's hard for me to go into. I would be here for another hour. I will give you a couple of samples of work that I have created. So this is from an employee handbook, and it's saying that it's not a contract. Sometimes these are policies and procedures. You want the workers to acknowledge that they've read this or they've seen this, but it's not a contract because you don't want to be bound by the terms. And I'm just going to give you some other samples. So here are my before and afters. On the left side, this is what the client sends me. This is their employee handbook. And on the right, this is all the things that I add to it, and then I put comments saying, is this what you want? And then I have to make a lot of changes. That's just the reality. I don't rubber stamp contracts that come into me. I do provide limited scope representation if they don't want me to review something. But this was from a client who, you can see in this, their confidentiality provision was very defective, it just wasn't very robust. And then I moved some of the other sections around, but I had to add in a lot of information, and then the applicable law, and they didn't even have anything about dispute resolution there. So I had to add the arbitration provision, which this is the shortest arbitration provision. They wanted something very simple. Like I said, it could be a whole separate agreement. Here's another before and after. This was kind of funny because my client said his business partner, and they were opening up a company, was represented by a lawyer, and the lawyer was very young, and I found out right away that the lawyer had pulled this contract off of somewhere online. I Googled something weird in it, and it was from a free registered agent site. And then you can see in this section how I made a lot of changes to it, and it's sad that it came from an attorney, but he wasn't very experienced. And so we got a lot of concessions because of that. And then here's so I always want to sit down with my clients and talk about why I'm red lighting things, and I'll put little comments to them like, is this what you want? And they can reply. But if you open a contract from an attorney, and they may go over everything on the phone, different lawyers have different styles, different clients prefer different things, but in order to get your contract effective, I want my clients to understand it. So that's how I work. Unless the client wants me to just do everything over the phone, then I can answer everything. But this is more efficient for the client because it makes their billable hours lower, and I don't want to run up their bill. Here's another sample. It was something I showed earlier. Again, you can see how I write comments on the sidebar. And sometimes people open the contract and it's not showing those changes. So I like people to be aware of the fact that you can utilize these tools to make your contracts compliant and effective. I wanted to bring up this because we were talking the other day about social media, and while we all want people who work for us to put forward the most professional style, there are freedom of speech and rights of employees to not have to do that. So this one is an employment lawyer approved contract provision about social media and blogging and posting, and so I would not recommend restricting anything beyond this. I know that I've written him a couple of questions to say, my client wants to do this, what do you think? And he says, no. And you should add that, add something else so that they don't end up putting that in their handbook. Here are just some surprising results that the National Labor Relations Board came to with some cases. They invalidated employment policies that prohibit employees from using the employer's logo in any manner. You can say that you want permission. You want the employee to ask permission first, but prohibiting in any manner is apparently not allowed. This one's funny. Apparently the employer wanted employees to identify themselves if they're making social media posts about the employer, and the National Labor Relations Board said you can't do that. And then requiring that employees represent the employer in the community in a positive and professional manner at every opportunity. It was just too much. They invalidated that handbook provision. So you have to be careful. I know that, I mean, as an employer myself, I would love to have that provision in my handbook, but unfortunately it's just not legal. So negotiation tips. I'm going to backtrack a little bit because I wanted to go over all those legal issues, but this is just how to get to a good contract. As a transactional attorney, I look at myself as I'm not very adversarial. I'm more looking to be collaborative in negotiations, so I try to start out positive, keep it light. We're looking for a win-win situation. I was raised in the South, so catching more flies with honey than vinegar comes naturally to me, and it's very useful not just for Southerners or for other people, but lawyers use that same skill set. I've seen this in legal seminars. It's also related to Stephen Covey's book. One of the 7 habits of highly effective people is to seek first to understand and then to be understood. So in a negotiation, you want to know, what is the other person looking for? Other people, sometimes they don't realize that, and they're just like, this is what I want, and then you end up butting heads, and it's not you don't reach a solution as fast, and sometimes, clients' time is money. You want to reach a solution as fast as possible, but you want to show the other person your understanding with evidence and data. If you guys reach any kind of agreements, writing them out on a whiteboard. If you're sitting together, writing a confirmatory email saying, okay, per our conversation yesterday, I'm glad that we reached these decisions on our work together. And if you're struggling, you can start asking questions like, is this how you really want this to look on the practice? Anytime you can say, that's right, we're in this together, trying to seek a win-win, it enables a more positive outcome with the contract negotiation. And then lawyers do this all the time. We're always supposed to anticipate counter-arguments, but you can do that too. You just, think about what are they going to start fighting me on? I have a call tomorrow, and I already listed out some of the issues that they're going to come up with in this contract that we're negotiating, and I already have points to make about why I think that the terms we put in are beneficial for both of our respective clients. And then, like I said, if you can't catch more the flies with honey, then we'll go to the vinegar. This is the contract disputes. So now you've tried to negotiate, maybe you've reached a contract, one person isn't performing, you did the right thing by asking permission rather than for forgiveness, and the stakes have gotten very high, or you're very concerned about the performance, the money you're spending. So one of the ways that you can deal with that is by having a good cop, bad cop routine. This can work not only with people who you work with, but like in terms of the contracts, but it works with patients too. I have clients who have disgruntled patients and employees, and they need me to talk to them, and so at that point the client is the bad guy. They don't like the client, and that could be the person who injected them and caused some sort of complication, or it could be the employer who is not getting along with the employee and wants to fire them. So at that point I'm going to try to reason with them. I'm going to use my seek first to understand, and then hopefully arrive at that win-win solution, avoiding litigation, which is very costly, which I'm always trying to do for my clients. The other thing is just calendar reminders. It sounds so simple, but there's a lot of contracts that will automatically renew after one term of, let's say, a year, and you have to give them notice prior 30 days that you want to terminate the contract. If you don't set a calendar reminder a year later, approximately a little less, to terminate that contract, then you might be on the hook for thousands of dollars. I've seen that happen with a variety of types of contracts that my clients ask me to help them get out of, and sometimes it's simple, and sometimes it's a fight. Sometimes it will drag them to arbitration. It's very simple, but calendar reminders are useful. Obviously, the common sense stuff, you've heard this repeated again and again, having the friendly person who can provide customer service, who has knowledge of what's going on. And this is interesting because I've seen some potential clients who I don't think that I would make the best attorney for them, because they come from a place of scarcity. It's like, no, they have to have things their way, and there's not enough patients out there, so they want to perform as many procedures as they can. But if you come from a place of abundance and that echoes in your negotiations, then you're less likely to get a dispute. And I did write an article about how to deal with difficult clients. It's for lawyers, but all the tips are pretty much relevant to dealing with difficult patients. Sometimes you want to have options for them that so that way maybe they are not getting everything they want, but they're getting some things, or you're not maybe getting all the money you want for a procedure, you're giving a partial refund, something like that. It just comes, there are a lot of ideas for solutions in that article. And that's pretty much it. You can connect with me on LinkedIn. There's my contact information, and I'm on Twitter and Instagram as well. Thank you.